So this lecture is probably about 8 months late in being given. The impetus for this was Imam Munir Farid had contacted me shortly after the Dobbs decision came down by the U.S. Supreme Court last June. And he and I had agreed that this has implications far beyond abortion itself. Implications that we weren't quite sure the Muslim community necessarily understood because, quite frankly, they were still being processed by us. For those of you who thought that this was going to be a lecture purely on the theological elements of abortion, I'm sorry, this is not going to be that lecture. If it really was, we have far more learned people in the audience who would tell you that the Islamic position is one, as you know, that ensoulment occurs at 120 days or 17 weeks, and that is a line of demarcation that tends to determine when an abortion is permissible and perhaps when it isn't. Of course, it is a little bit more complex, but I would certainly guide you toward somebody with more of a theological background. What we're here, inshallah, here tonight to talk about, though, is what are the implications for the Muslim American community on the Dobbs decision as it came down last year. And so moving from that, let's just go through a few very quick slides. I'm not sure how many people aren't in some way, shape, or form familiar with the debate of abortion in the United States. It seems to be, depending on the political climate, either the issue or within the top 3 issues that are discussed politically. It could be gun control, it could be the economy, but abortion is always lurking around in the political debate and has become one of these litmus tests that a lot of Americans use in determining whether or not to vote for a particular candidate. Here you see an example of the kind of energy and emotion that the issue brings up. This is the United States Supreme Court in Washington, and it is not uncommon that when there have been cases dealing with abortion that have been heard in front of the court, you will find a similar group of people here. Well, the case that we're talking about that came down last summer was called Dobbs, or Dobbs versus Jackson Reproductive Services, which is in Jackson, Mississippi. And it was a 6-3 decision that came down. So it's a majority decision. Usually a 5-4 is considered narrow. A 7-2 is a little bit more decisive. 9-0, of course, is unanimous. This was a 6-3. And unsurprisingly, the 6 justices that were in the majority all happen to be ones that are deemed to be conservative justices. You have the Chief Justice, John Roberts, Clarence Thomas, who's the oldest serving justice on the U.S. Supreme Court, was a George H.W. Bush, Bush 1 appointee. Samuel Alito, who was a Bush 2 appointee. And then we have the 3 Trump appointees, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, the most recent of the 3. And then we have the 3 dissenting justices. Unsurprisingly, all of them are liberal justices, Elena Kagan, Stephen Breyer, and Sonia Sotomayor. So the question to ask then is, what is the current status of abortion in the United States? And here you see shades depending on the state. Now, why is this important? Because the Dobbs decision made abortion outlawed on a federal level. It recognized, or I should say, it declared that abortion is not a recognized, federally protected right. And we'll talk about that in a little bit, inshallah. Well, if you take a look then when Dobbs was decided, where abortion became immediately illegal, we have what are called trigger laws. And so here we find Arkansas, Idaho, Kentucky, Louisiana, Mississippi, Missouri, North Dakota, Oklahoma, South Dakota, Tennessee, Texas, Utah, Wyoming, all had laws on the books at the state level that were anticipating that if the federal guarantee of abortion is out of the picture, then abortion will immediately be illegal in these states. The extent to which, of course, differs. For some, there are no exceptions for things like rape or incest. Other cases, they do have certain exceptions, certain medical exceptions. There are other states that have abortion bans on the books, but they may not necessarily be enforced yet. Alabama, Arizona, North Carolina, West Virginia, and Wisconsin. Michigan, by the way, has a law that bans abortion. But as some of you probably remember, last November, abortion was on the ballot in Michigan for a constitutional amendment, and the constitutional amendment then passed. So abortion is protected in the state of Michigan by the Michigan Constitution. Because what Dobbs did, and as I'll explain in a minute, inshallah, is that it threw the issue to the states, and each of the states would then be able to decide. Now, I will spare you, and you're welcome, to have to read the entire Dobbs opinion. It is both long and it is probably quite boring, except to people who like Supreme Court decisions. So most important language here is that we, meaning the court, holds that the Constitution does not confer a right to abortion. And then it talks about certain cases which I'll also describe. Roe, as in Roe versus Wade, which how many of you have heard of Roe versus Wade? Okay, most of you have, okay. The Casey versus Planned Parenthood case. All right. Have you studied this? Okay, so I take it you've studied this. All right. I can go next level to some of the other cases, but we won't. Okay. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. The elected representatives of the people are also at the federal level, but here, of course, the court was trying to say it belongs at the state level. Unwritten rights to be enforced by courts must be, quote, deeply rooted in our history, or an integral part of a broader right that is so rooted. Now, this is really dangerous language, because when it's talking about things that are deeply rooted in this nation's history, slavery was deeply rooted in this nation's history. Denying women the right to vote was deeply rooted in women's history until 1920. I mean, just think about it, that this side of the room 103 years ago would not have been able to vote. Part of it is you would have been too young back then, but I mean, you also wouldn't have been able to vote. African Americans would not have been able to vote until the 13th, 14th, and 15th Amendments of the Constitution, 1868, after a rather violent civil war. So language that the court is now invoking of saying that in order for there to be a right, it must be something that is part of our nation's history, is going to have implications going forward. And for Muslim Americans, you have to ask the question, are we deeply rooted in this history of this country? And what does that mean if the court deems that we're not? And also the fact that the right has to be an integral part of a broader right in the Constitution. And as the court has said, abortion is not there, but what the court was also trying to then show is that this idea of privacy, upon which all of these other cases were based, is not specifically in the Constitution. The court says in some states, voters may believe that the abortion right should be even more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. What are the implications of this? One of the things that supposedly keeps the United States together as the United States is the idea of having some kind of continuity. Obviously, if we go from Michigan to Ohio, we don't change the currency. We don't change the voltage. We don't change the side of the road on which we drive. There are certain things that keep the country together. Is it coming to the point where the question of when does life begin is going to differ depending on the state to which you belong? Is there going to be a difference that certain rights that women have when it comes to reproductive health are going to differ solely by a border between two countries. These are some of the implications and some of the things to consider. And again, I don't want to focus only on abortion. This could deal with any number of fundamental rights. Do you significantly change as a person just because you cross the border from one state to another in the United States? Well, a lot of this comes down to language, which I'm sure you studied painfully in detail, a term called due process. And due process in the US Constitution is generally, and this is a very sort of simplified explanation, is about whether you have the right to argue, protest, or have your day in court. Do you have the right to not just have something imposed upon you, but you have the right for a system to play out instead of things being random or arbitrary? And there's two basic kinds of due process. One is what is called procedural due process. And I'm sure many of you are very familiar with this. It says that the government must use fair procedures before it deprives you of life, liberty, or property. And so this basically is where it says that you are entitled to have your day in court. They can't just simply lock you up, throw away the key, or charge you with something, try you, convict you, without you having the opportunity to confront your accusers and have your case adjudicated before, hopefully, an impartial jury and or judge. And this is required by the Fifth Amendment of the US Constitution, which applies at a federal level, and then it applies to the states through the 14th Amendment of the US Constitution. So that's one part of it. But the part that really affects Dobbs, Roe versus Wade, and this line of cases is what is called substantive due process. And here it talks about the courts establishing and protecting certain rights which are considered fundamental to human beings, not just even citizens, to be free from government interference. That the government is not allowed to then impose itself or interfere on these rights. There are certain rights that are just so fundamental to being a human being that you should not have even the government step in. Some of these rights are considered to be unenumerated. The Constitution doesn't talk about these. The Constitution was written and ratified in 1791, over 100 or 230 years ago, by a group of white, Christian, free, property-owning males who couldn't possibly have imagined, well, let's just say us, or any number of other developments in American history. They certainly weren't prophets, they certainly weren't oracles, and to expect them to then be able to predict all of the things that society has become would have simply been too much. I mean, after all, this was at a time where this Constitution designated African Americans as 3/5 of a human being. That an African American was considered only to be 60% of a person. For that then to be the benchmark, for that to be then the standard of talking about all of the rights that they placed in the Constitution and all of the ideas that then they had about people and society would have been ridiculous to even consider. But we find that this idea is oftentimes cited by particularly conservative members of the Supreme Court, conservative members of Congress and the Senate, conservative members of society, that somehow or the other there was something about the original intent and understanding of the Founding Fathers of America that must be either kept sacred or that we should return to that now. But the Founding Fathers did leave an escape hatch in the Constitution. And they said in the 9th Amendment that certain rights are enumerated, but other rights that perhaps we left out because we didn't think of them are retained by the people. Now the question then becomes, are these then rights that we can assert, or are these rights that the court can determine for us? One of the biggest issues that plagues the abortion cases, whether it's Roe versus Wade, which came down 50 years ago, or Dobbs, which came down last year, is this word privacy. Because privacy has been cited as a fundamental right. And if you were to read the decision of Roe versus Wade from 50 years ago, abortion was protected as part of a woman's fundamental right to determine her own reproductive rights and her reproductive health. Roe versus Wade created the contract between a woman and her physician to be able to make that determination, especially when it came down to what was in the best interest and particularly the health of a woman. You can Google or you can do a word search of the United States Constitution, and I can guarantee you, you will not find the word privacy anywhere. It's not there. Not even if you look down the left margin of the Constitution and you took the first letter of every third line and tried to make it, you're not going to find the word privacy. Conceded that point. But the question is, if it doesn't appear in the Constitution explicitly, does that mean that we as Americans don't have a right to privacy? It would be ridiculous to think that we cannot keep our private rights from public display or from government interference. And so some will argue then that you don't even need to use the P word explicitly. It's actually already in the Constitution if you know how to read the Constitution. If you look at the First Amendment, which has among its many freedoms, freedom of religion, freedom of speech, freedom of press, there's also the freedom of association. You have an absolute right to associate with anybody you want. Even if the government doesn't like that person, you have a right to associate with them. That means that your privacy right is protected. If you were to have, and I'll let you think of somebody who the government won't like, you decided to have them over for a dinner party, the government cannot go ahead and stop you from having that person over for dinner. The Third Amendment, and I know this is an amendment that doesn't seem to apply today, but trust me, I'm glad that it's there. The Third Amendment prohibits the government from just showing up at your house and saying, we have some soldiers, we're at a time of crisis, you have to go ahead and house them. This, of course, was a big fear right after the American Revolutionary War, that the government could just simply have part of the militia or the soldiers show up. You don't have to let them in. You don't have to feed them. You don't have to clothe them. You don't have to let them watch Netflix. Well, if you don't have to let them in, then that means that you're protecting your privacy. You're keeping your home sacred from that kind of intrusion. The Fourth Amendment, prohibiting against unlawful search and seizure. You walk out of the IAGD, walking down the street, police cannot just stop you and go through your pockets. They cannot just show up at your home and do an unlawful search. They have to have probable cause. There needs to be a warrant. So that then suggests that privacy is protected. It is guaranteed as a right. Again, no language in the Fourth Amendment that uses the word privacy specifically. The Fifth Amendment, and I know many of you from watching enough TV shows know that you have the right to remain silent. Anything you say can and be used against you in the court of law. You have the right to an attorney. If you cannot afford an attorney, or an attorney will be provided for you. It was even on Matlock this morning. Well, that means that if you can protect yourself from self-incrimination, that's a privacy right. The Ninth Amendment with unenumerated rights, and even the 14th Amendment, you cannot allow the privacy of your liberty to be violated without some kind of due process. So when people talk about privacy being in the Constitution, this is how they talk about it. And of course, you notice there's one amendment that I haven't talked about, which a lot of people consider to be the most sacred, which is the Second Amendment. The right to bear arms. That is, in many ways, a privacy right. And it's fascinating to see that those people who oppose abortion but are for gun rights will argue that it is their privacy right of guns that is to be protected, but they don't have the same feeling when it comes to reproductive rights. Now, when we think about Roe versus Wade, we think about it, of course, as the case that legalized abortion in the United States in 1973. It was a 7-2 decision by the US Supreme Court. But if you know anything about constitutional law, you know that cases at the Supreme Court level are usually based on past precedent. There have to be certain kinds of constitutional ideas and interpretations that are then used in order to cite. To use as a parallel, for those of you who are familiar with how fiqh is determined in Islamic law, there is, as the ulama would go ahead and cite, using past precedent of looking at where in the Quran, where in the Hadith, and then using the methodology of the various madahib, how do you then reach a conclusion or a result for something now that perhaps was not considered 1,200 years ago, 1,000 years ago, 800 years ago. When it comes to Roe, a case that had at its very foundation then this idea of privacy. Privacy was something that was actually determined in cases that began about 8 years before Roe. And they began in a field that today would seem rather odd that cases went the other way. One of the most famous was in 1965, a case called Griswold versus Connecticut. In the state of Connecticut, until 1965, it was illegal for married couples to purchase contraceptives. It was illegal for even married couples to be able to acquire birth control of any kind. Now, of course, if you're Catholic, you could say, what's the big deal? Because in the Catholic Church, any form of birth control is prohibited. But this nation is not just populated by Catholics. In fact, the population of Catholics is rather small compared to the larger Protestant Christian community. But this was the law that prohibited in Connecticut the right for married couples. The Supreme Court in the Griswold case said this law is unconstitutional, and they said that this violates a married couple's fundamental right to determine their family planning. It was of such an intimate level of intrusion into their lives that this cannot be allowed to happen. Well, how does this then deal and reconcile with the idea that the US Constitution does not mention the word privacy? The justices, in their opinion, said that privacy exists not explicitly, but through these other amendments in what's called penumbras. So what they were talking about is if you've ever, well, actually, none of you should ever do this. Don't ever stare directly at an eclipse. The last person who did that was, I think, Donald Trump, very famously. But what happens is when you see the moon blocking the sun, you can still see the glow around the disk. That glow is called a penumbra. And so what this rather flowery language in the Supreme Court was saying, and sometimes the Supreme Court justices do have some skill in writing, they were saying that privacy exists as a glow from existing rights that are protected in the Constitution. So think about this. I mean, 2 years before I was born in Connecticut, the right for married couples to obtain birth control was not allowed. 7 years later, that fundamental right was extended to unmarried couples in Eisenstadt versus Baird. So a year before Roe, the notion of privacy, especially in issues of reproductive planning, were determined by these two cases. Now, when Roe comes around in 1973, it was dealing with a Texas law which made it a criminal act for a woman to get an abortion at all. And this was a case that was decided very, very carefully. First of all, it was Roe versus Wade that came up with the whole notion of the trimester. And it was determined when a woman can and when a woman cannot necessarily have an abortion. A lot of people misinterpret and misunderstand what Roe versus Wade permitted. It never permitted a categorical, universal, on-demand right to abortion. It said that in the first trimester, so basically the first 12 weeks or so, here a woman's decision to terminate a pregnancy is one where the state, meaning the government, cannot step in and ask any questions. She has a full right to go ahead and do so. In the third trimester, near the end, Roe versus Wade said abortion could possibly be illegal, but left an exception for the mother's health. If a mother's health was in danger and if it was determined by a physician, then an abortion was permitted. Of course, where it really becomes then a contentious issue is in that second trimester, between about the 13th week and, help me out with my math here, somewhere around the 25th, 26th week. Okay? The term fetal viability came into vogue because of Roe versus Wade. Fetal viability was determined as the point where the fetus could survive outside the womb, based on technology of 1973. Now, in the last 50 years, for anyone who knows anything about neonatal care, you know, of course, that the level of care, the technology has soared since 1973, which means that with incubators and with other care, the point of viability could be earlier. So keep that in mind because I think it's a very important one. But what Roe versus Wade said is that the mother's right to determine her reproductive rights and health are here in the first semester, and the state's rights are down here. By the third semester, the state's rights in protecting potential life. They don't say when life begins. That's something Roe never did, and Justice Harry Blackmun, who wrote the opinion, was very careful not to get into that determination. He said the state's rights to try to protect potential human life then are up here compared to a woman's right to just simply make any decision. So the second trimester then becomes, for lack of better words, the balancing point for Roe versus Wade. And this then, of course, becomes very critical as we move past Roe versus Wade over the last 50 years, especially when it comes to technology, when it comes to medical science, and when the point of fetal viability is. Now today, and I'm not a doctor, the point of fetal viability is certainly much earlier than 26 weeks. Does anyone know, is it now 20? $22? Okay, thank you. So it's at about 22 weeks. So it has moved back or moved up an entire month or 4 weeks within the gestation period. That's a fairly significant amount. So when it comes to privacy rights in Roe, outlawing abortion would infringe a pregnant woman's right to privacy for several reasons. Having unwanted children may force upon the women a distressful life and future. This is all what Roe said. It may bring about imminent psychological harm. Caring for the child may tax the mother's physical and mental health, and there may be distress for all concerns associated with the unwanted child. But as I said before, the court rejected the idea of an absolute right to privacy. They recognize that at a certain point, the fetus will have rights, and rights that the state can intervene and try to protect. Again, it's a balancing test, and it allows states to determine certain elements when it comes to when it could possibly intervene. But the overall right to abortion was provided by Roe. The controversy only then begins to get more heated. The so-called pro-life, anti-choice, or anti-abortion movement really gained steam throughout the 1970s, throughout the 1980s. It becomes a very politicized issue, and it culminates in 1992, only 31 years ago, in what is known as Planned Parenthood versus Casey, a case out of Pennsylvania. Casey at the time was the governor of Pennsylvania. And this opinion was a 5-4 opinion, and it was very, very close. The other issue, though, with Casey is you notice the word plurality, which means that you had 5 justices who agreed in principle with the decision, but not the opinion. So whether or not Casey could be binding as law was then a big question. They preserved the right to abortion that was there in Roe versus Wade, but they did get rid of the trimester system, and they then started to focus more on this idea of fetal viability, and more specifically this idea of what's called an undue burden. If there were restrictions that were being placed on women and their ability to access certain kind of reproductive health and access to doctors and access to abortion, as long as it wasn't considered an undue burden by the courts, then it was okay. Now, how do you determine this? Does that mean that you don't necessarily have abortion available in a certain county? If it's available in the next county over, is that then seen as too much of a burden? This became a big issue, and there was a lot of economics that came into it. For the wealthy, it wasn't a problem to go to the next county. It might not even be an issue to go to the next state. What about if people didn't have money or if they didn't have access? Is that then considered to be an undue burden? So Casey comes along and starts to chip away at what was seen as the edifice of Roe versus Wade, but it didn't get rid of it, obviously, completely. There were attempts throughout the years to provide more and more restrictions on how a woman would be able to get an abortion. You find states started to pass laws saying that doctors who were performing abortions had to be within a certain distance of a hospital. They could not perform this in a clinic because at this time, many places that performed abortions were actually clinics. Some which were Planned Parenthood and other kinds of private organizations. Some hospitals may not necessarily have performed them, especially in some more conservative areas. And so we find that laws were now being passed saying that abortions cannot be provided unless you're within, say, 50 miles of a hospital, ostensibly to protect a woman's health, because a hospital has more services than a clinic does, even though a clinic would have had a full licensed staff and all of the facilities. So again, these are ways to try to find ways to chip away at Roe versus Wade. Well, finally, we get to then last year's case. And if you understand the politics of abortion, you can also imagine that these cases were already being considered in anticipation of the right composition of the Supreme Court. And so when finally, with former President Trump, there was the appointment of a majority of conservative justices, this was now time to go ahead and take it to the next level of actually filing lawsuits. And remember, these lawsuits take a long time. They have to go through the federal district court level, they then have to go through the Court of Appeals, and then they have to go to the Supreme Court. And the Supreme Court generally gets in a calendar year somewhere between 4,000 to 6,000 requests for appeal, what are known as writs of certiorari. And the court takes at best 150 cases, so 1 out of 40. And out of those 150 cases, they might hear 40 or 50 cases in oral arguments. So it is a very limited number of cases. The fact that they take this case means that they probably wanted to take this case. All right? Well, it was a 6-3 opinion by Justice Samuel Alito, George W. Bush appointee. If you remember, there was a leaked draft opinion of the Dobbs case, which created a lot of controversy. And to this day, despite having an investigation at the Supreme Court, they haven't been able to find out who leaked it to the media. I've got certain ideas. I mean, there's only 9 justices, and each justice has only 4 clerks. There's fewer people who are involved at the Supreme Court than are sitting in this room. So it has to be one of you, or the same number over there. Well, this was dealing with a 2018 case in Mississippi that banned most abortion operations after the first 15 weeks of pregnancy. And this was known as the heartbeat case. The fact that the heartbeat of a fetus can be determined by ultrasound at 15 weeks. And Mississippi then said that if we can hear the heartbeat, then the fetus is alive. It doesn't matter that the fetus could not survive outside the uterus. It does not have viability, but they're not going to use the viability standard. All it would take is just the heartbeat. And so the law was then challenged by the only remaining abortion clinic in the entire state of Mississippi, the Jackson Women's Health Organization. But the court was ready for this, and it was almost as though the opinion had already been written. The court holds that the Constitution does not confer the right to abortion and gets rid of Roe and gets rid of Casey and the reasoning behind that. And they said that the authority to regulate an abortion now is returned to the people and their elected representatives, meaning the states. The way that the United States operates is that the federal government cannot go ahead and simply block the states from acting on something. They can get rid of it on the federal level, and then they can leave it up to each of the states to decide. The decision says that the Constitution makes no reference to abortion, which is absolutely true. I'm not sure if the Founding Fathers even knew what that was. And no such right is implicitly protected by any constitutional provision. So if you see the language, remember what I told you about Griswold versus Connecticut and the contraceptive or the birth control case, where they decided that privacy existed because it was implicit within other rights and other amendments in the Constitution. So not only did Dobbs get rid of Roe versus Wade, Dobbs also gets rid of the rationale that was used in the birth control cases in 1965 and 1972. That becomes important in a minute. The Due Process Clause of the 14th Amendment has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition. So basically they're saying is that you're going to be penalized for asserting a right to abortion about 100 or 200 years after the country's formation. That's the penalty. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. So you can see the attitude that was there for Roe. They tried to mask it as being an act of judicial misinterpretation, misunderstanding, and a wrong decision-making process. Of course, I think most cynical people see that there was something else behind it. They then shift the level of scrutiny for cases involving privacy and gender. Now, this is where it becomes very important beyond just abortion. The court can go ahead and limit your rights, or government can limit your rights. But depending on your status, they have a higher burden of proving why they should do it. There are certain areas in the United States that, because historically they have been problematic, the government has to have a very high standard, what is known as strict scrutiny, in order to discriminate. Race is one of them. So the government could arguably discriminate based on race, but they have to come up with a very compelling reason, and the means by which they do it are very narrow. Well, when it involves gender, historically, women have been marginalized, women have been discriminated against in the United States. Women only got the right to vote by the 19th Amendment in the year 1920. Here, it is called an intermediate scrutiny test, which is slightly less than the strict scrutiny test. But now, what the court is saying in Dobbs is we're not using any of that. We believe that we can discriminate against women, and we can have it at the lowest standard of scrutiny. We don't need an awful lot of justification in order to be able to do what we are. Okay? So within what seems to be the stroke of a pen, the court then got rid of 50, 60, 70 years or longer of how it decided cases. One of the reasons why the Supreme Court has been the way that it is and how it operates over all these decades is that whether people agree or disagree with a decision, there is a lot of deference given to past rulings. It's a principle called stare decisis. It's why then, when a new Supreme Court sits, the Supreme Court decisions don't go back and forth like a ping pong match. Because if that were to happen, America's entire society would be sitting there going back and forth, back and forth. Even though the decisions may be ones that aren't agreed upon by a new court, they have to have some very strong reasons why they would overturn a past decision, all right? Now, let's take a look at how various religions view the issue of abortion. This was by the Pew Research Center, which does a lot of work on studying religious communities. And you'll notice that all the way on the right, it says that there's no clear position in Islam. I'm not sure why they put Islam on that level. I have a feeling it's because it didn't necessarily fit conveniently in the other three. And like in many other ways, they didn't just find another category for Muslims. If you look at those groups that oppose abortion with few or no exceptions, you find that, interestingly enough, Hinduism, Southern Baptists, Mormons, Catholics are all in one category. Episcopal Church, some evangelicals support it with some limits. Supporting it with few or no limits, certainly the Jewish denominations, the Presbyterian Church, and the Unitarians, among others. So America is all over the place when it comes to, at least from religious communities, how they view the issue of abortion. And part of it has to do with the fact that religious communities differ on when does life begin. Because if life begins, then of course that changes the debate completely. How do you then take a human life? And remember, I said that in Roe versus Wade, the question was never dealt with by the court. They didn't talk about when life begins. They talked about when potential life begins. It was always contingent. Well, what are the implications of this? Who decides when life begins? Should it be determined by 9 judges? And actually, in this case, fewer than 9, 6 judges that were not elected, but were appointed and then approved by the Senate. What about the idea, as I mentioned before, that in Michigan, life may begin in the 15th week. In Ohio, it begins in the 10th week. In Texas, it begins in the first hour. In California, when you're 3 years old, when does it begin? And what does it say then about a nation where something that would seem to be so fundamental and so unanimous has that kind of variation? But then again, in this day and age, I think there's some states that believe the earth is round and other states probably believe the earth is flat, so who knows. Is the fetus a person? What does it mean to be a person? Is abortion a killing? Is it considered a murder? Is a miscarriage a killing? Is it manslaughter? There was a case in Indiana 5 years ago. It was an Indian woman who had a miscarriage, and Indiana law prosecuted her for manslaughter. Okay? She was charged, she was tried, and she was convicted of manslaughter. Now, notwithstanding the kind of psychological trauma of actually losing a child, this is not something that she did voluntarily. This was a biological process, but Indiana law still, nonetheless, criminalized her for manslaughter. Now, by the way, manslaughter is the same criminal charge that has Ethan Crumley's parents charged for aiding and abetting, if you will, by giving their son a gun and also ignoring his mental health issues. What about extended liability? Nobody has thought about what it means to other areas of existing law, including tort law and criminal law. If there's a car accident, supposing for some reason, say you're sliding, slipping in bad weather, you hit somebody, you don't know if the person you hit is pregnant and that person loses the fetus. Are you now criminally liable for that? Okay. What does it mean for car insurance? Is there going to then be, and I don't want to sound crass when it comes to economics, but economics, of course, is a very big deal. Does the fetus get full rights? Now, this is actually based on a real-life case. A pregnant woman in Texas was, and by the way, we have, in Michigan, we have no idea what this is, HOV lane, which is the carpool lane. You'll see this in some states, the HOV lane. If you have 2 or more people, you can use that lane, and it has less traffic on it. High occupancy vehicle lanes, yep. You'll see this around outside Washington, D.C. You'll see this in Texas and other places. Well, so in Texas, this woman is driving down the road, and she's in the high occupancy vehicle lane. And she's the only person that has a seatbelt on, shall we say. She gets pulled over, and the cop goes to ticket her and says, "You're in violation because you're in the HOV lane." She says, "I'm not in any violation." And he says, "Why not?" He says, "I'm pregnant." And it's like, well, now in Texas, now that Dobbs has been decided, this fetus is a life. This is a person. Now, again, it may seem like an absolute mockery, but you cannot go ahead and hold people liable in the one case and then also consider her to be riding solo in the other case. So these are some of the things that you can expect to now have to be adjudicated and legislated. What are the benefits and the entitlements for fetuses when it comes to health insurance? Does anybody have an health insurance policy through their employer that also recognizes fetuses as a life? I mean, I know that when I fill out my tax withholding, I cannot, well, not that I'm having any other kids I know of, that I cannot go ahead and put that number down. Otherwise, I mean, that would be a tax bonanza. And plus, how would you be able to prove it anyway? Now, think about also the cases that have been using Roe versus Wade and that whole notion of privacy as a backbone. I mentioned Casey. We have cases dealing with privacy regarding homosexuals. Lawrence versus Texas. In 2015, the case by the Supreme Court that decided and expanded the definition of marriage. But look at what is going to be the potential impact of Dobbs. I know how people might feel about the Lawrence versus Texas case. I know how they might feel about the Obergefell versus Hodges case. But right now, it's an open question about whether cases dealing with birth control and contraception are safe from this kind of constitutional interpretation. And in fact, if you read statements that have been made in concurring opinions by conservative justices like Clarence Thomas and others, they have already indicated or given hints that these cases are also, if they do come before the US Supreme Court, they will most likely get struck down, meaning that there is the possibility that birth control in some state or will become an issue on a state-by-state basis, and some states it may be accessible, and in other states it's not. Now, on the one hand, you could say, hey, no big deal, I will go and drive to another state and I will pick it up. There are already laws that are being passed in states that are looking to criminalize people who travel from one state to the other in order to get medical services which are legal in the state where they're going. So for example, Michigan now is essentially going to become a safe haven, a destination state for women who want to have certain kinds of reproductive health treatment and services. There is a possibility, if you were in Arkansas or Oklahoma or Texas, that if it is determined that you go to Michigan for these purposes, it could impact your job, it could impact your criminal liability for doing so. Once upon a time, I would have been here telling you it is ridiculous to even think that such a law would even be upheld by the Supreme Court. And now, thanks to Dobbs, most constitutional scholars cannot say that with any level of certainty. How is it going to impact privacy cases? We don't know. How is it going to impact other cases with other kinds of fundamental rights? Will the Supreme Court now say, well, since it's not written in the Constitution, it's not there historically, well, I guess we can go ahead and get rid of it. And what's the potential impact on cases if and when the court composition changes? Now, I know most of us here, if not all, are impacted in some way by what happened in Michigan State a few days ago. And I know, once again, we're at that point where we're thinking about gun control. And we know, of course, that there are many, many people, including, as you might have seen at the State of the Union address, politicians wearing assault weapon lapel pins to show their support for the Second Amendment, the right to bear arms. It is a highly contentious issue. Let's say, for the sake of argument, that in a few years, the Supreme Court is not 6-3 conservative majority. Let's say it flips, and let's say it is 6-3 liberal or left-leaning. The question then becomes, if there is a case that comes before the Supreme Court that places limits on the Second Amendment, gun control, gets rid of assault weapons completely, puts limitations on how much ammunition you can have, forces background checks, forces mental health tests, gun safety, basically gets rid of everything that the NRA has now had. How many of you would support a Supreme Court case or decision that restricts the Second Amendment like that? Don't worry, the camera's looking at me, so this is basically an anonymous vote. The question is, if the Supreme Court changes its composition and comes in and basically defangs the Second Amendment, how many of you would be in support of that? I would go ahead and say 1, 2, 3, but I don't want to incriminate you. You do have Fifth Amendment rights so far. Well, okay, and I fully understand that. But here's, from a constitutional standpoint, one of the dangers. The reasoning why that court will be able to do that is not going to be because of other gun cases, it's going to be because of Dobbs. Because they're going to say, hey, Dobbs, you took 50 years of a fundamental right and you basically crunched it up and threw it into the garbage can. We can do the same thing on the other side. Now, I'm conflicted about this. On the one hand, if they went ahead and got rid of everything except a paintball gun, I wouldn't be necessarily disappointed given the fact that here we are now in the 7th week of this year, and we're averaging 10 mass shootings a week. It's the only country on earth by far that has this disease. But I also have to consider, does one wrong make the other right right? Or the other wrong right? Do two rights make a wrong? You know what I mean. Do two wrongs make a right? I have to worry that this now opens up a whole can of worms, that the Supreme Court is going to be nothing but a tit-for-tat, ideological, settling scores kind of an institution when it was never supposed to be. If there are going to be restrictions, and I know everybody's emotions are very high because of yet another situation so close to home, is this the place and is this the method by which that needs to happen? So something to consider. And here again, stare decisis. Do we have any kind of respect for past precedent? What about the notion of substantive due process? What are fundamental rights, and can this court go ahead and limit them now? Privacy, especially marital privacy. Marriage. In some countries, Islamic marriages are not recognized by themselves. They have to be then registered. What about in the United States? A nikah is not exactly the same as how other marriages are conducted. Could that then be threatened? The right to travel, voting, a presumption of innocence in a criminal case, right to fair trial, right to a jury of peers, judicial review, right to education, right to send children to IAGD school. Will that then be impeded? Do you have a fundamental right to send a kid to a religious or a faith-based school? You have a right to practice your religion, but that may not be seen as, a fundamental or a core part of how you practice your religion. Right to health care. What does it mean, as I said before? I know some of you want to leave the state of Michigan, especially young people. It's boring and you want to go someplace more exciting. I get that. But what does it mean that if you leave the state of Michigan, you now have to consider that you're a different person because of how the law and how the courts see you? How does that affect you? Is it going to, in fact, then impede your decision to travel? I know maybe your mom and dad tell you shouldn't travel, but what happens now if the courts step in and do that? What's the danger that the court is going to become yet more politicized? And what is it going to mean when, as I showed you that slide in the beginning where you see these kinds of demonstrations, when are the demonstrations going to get bigger? When are they going to get more bolder? And when are they going to get more violent? There has already been enough bloodshed when it comes to the abortion issue in the last 50 years, bombing of clinics, the murder of doctors, the murder of nurses, the murder of women who have been getting that. How is this then going to play itself out in other ways? With that, inshallah, I'll take any questions you have. Jazakallah khair. How many of them are Catholic? Oh, thanks. Let's go back and see. Actually, this is the first time in the court's history, I believe, that there's no Protestants. There are, Kagan and Breyer are Jewish, and I think everybody else is a Catholic. Yeah. For those who think that religion isn't in the court, it's everywhere in the court. Yeah. So, any other questions? Yes?
What does Islam say about this? What's the ruling of Islam?
On Dobbs or on abortion? Well, would somebody who is more Hafiz Rabbani? You picked quite a time to eat. I don't think that was by accident. So I can give you, if you'll permit me.
Some Islamic scholars say something else, some sort of confusing.
Yeah, what we know for a fact is this, that according to the ulama, the soul enters the body at 120 days, okay? 17 weeks or so, if my math is correct. At that point, the notion of, in many ways like the architecture of Roe, kicks in, that when do rights end? When do rights begin for the fetus? Because now it's considered a life. Those kinds of issues then become matters that are not strictly about law, but they're also matters of ethics, whether it is right to go ahead and do so. What is the spiritual accountability as opposed to just the social accountability? Yeah, there's a former Supreme Court Justice, Potter Stewart, once said that the difference between describing ethics, he said that just because you have a right to do something doesn't mean that you that it's right to do something. So that's what it is. Yes.
Thank you again for the great lecture. Two questions. One, why is this such a big issue only in the United States? Why not in the outside world? And the second question is, why was Islam on that rightmost column? Why
Yeah.
are we undecided about it?
Well, I wouldn't say that we're undecided. I think that if you recall, the slide said that it's not settled. And again, part of it is because how Muslims then operate within a system has to do with both legal as well as ethical implications. I mean, there's nothing to stop a Muslim from going ahead and doing X, Y, and Z, even if it may not be halal to do it. There's no enforcement mechanism to go ahead and stop it. So I think that's probably how Pew viewed it. As far as the question about whether it's only happening in the United States, Ireland very famously or notoriously had banned abortion for until fairly recently, Ireland being a very Catholic country. And in the early 1990s, there was a case of a 13-year-old girl who was raped. And she was made pregnant by, I think, an uncle. And she then was seeking to get an abortion. And not only was it illegal for her to get an abortion in the Republic of Ireland, she was denied an exit visa from Ireland so that she could travel to Europe in order to get it. Finally, after some kind of intervention, she was able to get that dispensation, and she got the visa. But imagine the psychological trauma. And this wasn't a quick process. I mean, she had to go through the courts, there had to be intervention, and the whole time the clock was ticking. And so that fetus was getting bigger and bigger and bigger, and her body was going through the changes accordingly. So this was not a good solution to it. More recently, Ireland has changed. Part of the reason why this is a bigger issue in America is America's actually a fairly young country. In other countries, these things have been decided one way or the other in a very definitive way. So, yeah.
Two questions. The first one is, what was the court composition back in 1973 when Roe was passed?
Mhm.
Was it the other way around? And then the second question is, you were talking about respecting the past incidents or whatever. So dogs, by overruling Roe, hasn't that opened the door for that already?
Great question. So the first question is, what was the court's composition during Roe versus Wade? Actually, it was, back then, I'm not sure we would have said that the court was overwhelmingly or even majority center-left. It was the Warren Burger court. Now notice it was a 7-2 opinion. I would say that you probably had maybe two people who would have been called conservative by today's standards, two who would have been considered liberal by today's standards, and you had 5 who were centrists. And if you want to know what centrist is for a Supreme Court justice, don't look to this court, because that day is gone. I don't know when it'll come back. I think the last centrist on the court was maybe Anthony Kennedy. But when it comes to the Roe versus Wade composition, it was only the conservatives who voted against, who dissented. The 7 who voted for it were the centrists and the 2 liberals. Now the second question is regarding Dobbs, and as you asked, whether or not they got rid of this whole institution of stare decisis or past precedent. Yes. they could have come to a conclusion of overturning Roe versus Wade without necessarily being so dismissive of stare decisis. And courts do that all the Supreme Court does that all the time. I mean, after all, if you think about it, back in the 19th century, there was Plessy versus Ferguson, where you had separate but equal when it came to schools for black kids and for white kids. And that was proven to be fundamentally unequal. And it wasn't until 1954 with Brown versus Board of Education that they overturned the Plessy case. But they could say that because there was evidence that there was never any equality that was achieved or even achievable, as Brown said. In the situation with Roe versus Wade, I think one of the problems was it was such an overreach. This court didn't want to just outlaw abortion, it seems. They wanted to kind of run the table and put down a marker when it came to privacy as a whole. Clearly, if you listen to some of the statements after the decision came down, in interviews as well as in the opinions and the concurring opinions, Clarence Thomas, for example, has Obergefell versus Hodges in his line of sight. He's waiting for another challenge on the issue of same-sex marriage. This court wants to go ahead and get rid of that too. And Dobbs now has set the stage for the ability to do that. Now, of course, again, there are going to be people of various faith communities that will applaud that. They will see that as a positive development because they don't like what Obergefell did. But the question is, what else will be done that will affect those religious communities? Because this court isn't just going to stop when it with that case or with that particular issue. Yeah.
So if Dobbs repealed all those past court decisions, what does that mean for the future of like married couples obtaining contraception?
We don't know. That's exactly the issue. There have been some statements made by people like Alito, who is very Catholic, and so the whole notion of contraceptives is anathema to Catholic teachings. We don't know if the right case comes up in front of the Supreme Court, whether they will then say, you're right, there is no privacy. We can go ahead and get rid of it. I'm not saying that that's a reason to become paranoid or to start to worry what's going to happen, but I think what it does do is it calls for then a vigilance that people didn't have. Elections matter. Deciding court composition matters. These are litmus tests that have to be explored. They have to be examined. So I think that your concern for that is absolutely spot on. So, yes?
And I just wanted to know if we wanted to take like action as parents against like how do we go about it?
Against which, I'm sorry? Against the Second Amendment.
The right to live, right for the kids to live.
Yeah.
Who's against that?
Yeah, that's a great way of looking at it. I mean,
You're not giving the kids the right to live like other kids around the whole world.
so,
Taking away that right.
yeah, so, yeah.
Common person walk to the court, like in Pakistan, if I don't like what people are talking about army or Imran Khan, I can go and file a petition. So can a common person walk to the court and challenge the decision, the court's decision, like the U.S. setting?
But against the Constitution, I mean, how
Right.
it's a big
Right. Okay. Yeah. Thank you for that. First of all, just one correction: there are no common people in Pakistan. Everyone's exceptional. You know that, right? Yeah. 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 No. That's actually a great question. That is not something that is permissible in the U.S. court system. In the court system, you have to have what's called standing. You have to have yourself a personal stake in that particular case, in which you can then be a party to the case. Now, the Second Amendment and the issues are going to be solved by really two things. One is mass mobilization of people, and the other is money. the amount of money that the gun lobby, and not just the NRA, puts to politicians is insane. And they will vote exactly who's paying the bills and who's giving the money. So that is really, today I was on a podcast called The Week That Was, and this was the discussion. Unless and until either money is taken out of the system, and by the way, the U.S. Supreme Court is responsible for allowing now unlimited amount of money to be in the political system, thanks to a case in 2010 called Citizens United. Citizens United declared that making a political donation is protected because it's a form of speech. So there you go. But you had your hand up again for...
Yeah, no, I was like, is there any way we can prove that a Second Amendment was brought by maybe the gun lobby somehow?
Well, the Second Amendment itself was not, because the Second Amendment came about in 1791, well before the NRA ever was in its inception.
Someone who started like the industry or something.
Well, what it is that the Second Amendment, as it is interpreted now, is really a function of conservative U.S. Supreme Court decisions, without a doubt. The very idea that assault weapons are considered to be part of your right to bear arms, that's all from that. So again, what we're then looking at is the possibility of having laws passed, which is step number one. But then we also have to worry about a Supreme Court that might strike down even reasonable laws because of the way that they perceive the Second Amendment. So this is sort of a multi-tiered challenge that we face. Yep.
But when it comes to gun control, even the most liberal will not touch the Second Amendment. It's only the assault weapons. Even the state of Michigan
Mm-hmm.
is drafting the bill, right?
3 bills.
3 bills.
Yeah.
But it's not about banning the guns. It's federal, black flag, and assault.
So the Second Amendment does give Americans a constitutional right to bear arms. And I don't know anybody who wants to get rid of that completely. But the problem is that even sensible, reasonable limitations are not being considered.
But the point is that
Yeah.
that point that somebody can go and change that can't happen. Because even the most liberal people will not go for that.
At this point there's so much money that's available on the other side that there is a genuine fear that anybody running against somebody who represents the gun lobby is going to lose in the election. Even let's say somebody like a Rashida Tlaib, who's running in Michigan 12, or is it 13, she pretty much can win because she's a Democrat. But even she will not go ahead and touch this issue because it's radioactive. So, and to be fair, one of the issues when it comes to the American political landscape is that reasonable limitations on access for abortion were blocked by progressives and people on the far left. So when it came to ideas of even upholding what Roe versus Wade said, that yes, there should be some kinds of abilities for the state to intervene in the third trimester when it comes to partial birth abortions, if it's not something to save the mother's life or the mother's health being an issue, those were being blocked as well. So I think that the problem with many of these issues is that they have become just simply so politicized that reasonable expectations, reasonable curbs are just not part of the equation anymore. So, yeah. It is a possibility. There's 2 years left in this term. And, there's always the possibility that something could happen to the conservative members of the court. And if those vacancies happen, then Biden has every right to. Remember that one of the problems was that Obama had and should have had a right to go ahead and appoint a justice when Scalia died. But Mitch McConnell blocked that. That was one of the sleaziest things ever. He says we can't have a nomination in the second half of an election year. I mean, I don't know where he came up with that, but that was not something that was fought for. I mean, that should have inflamed the country. And then Ginsburg, unfortunately, Justice Ginsburg, I mean, she was extremely ill. If she would have gone ahead and retired, it would have allowed Obama to go ahead and pick another justice. But she died during Trump's era. I mean, she had a lot of issues. So yes, there is the possibility. I mean, if you think about it, I mean, at least Clarence Thomas. I mean, God, I mean, why is he still around? But the fact that COVID didn't get at least one, justice still mystifies me. I mean, I'm just going by statistics here. I'm going by statistics. Right, but I mean, if something happens to Biden, his vice president is a Democrat, so that's okay. I mean, Kamala Harris would, I hope, step in and then appoint or nominate somebody who would be there. And you see that there have been other issues that have been proposed. Biden expanding the Supreme Court to 13 justices, which, by the way, is perfectly legal and within his rights as president to go ahead and do. He can expand the court. Politically, it's suicide because, of course, it then just politicizes the court even further. Franklin Roosevelt actually had this idea back in the 1940s. He was really worried that the Congress would not pass his New Deal legislation. So he says, well, let me go ahead then and have a court that will make sure that those things are not declared unconstitutional. And his advisor said, no, man, that's a terrible idea. So he didn't. Otherwise, he was ready to appoint 4 more to dilute the effect of the opposition on the court. There's also, I would say, some more creative ways that we need to explore some of these issues. And I don't think that there should be a lack of courage in saying, I think, your example of invoking children and their right to life or their right to live is an important one. For me, I think that a woman's right to be able to have an abortion should be decided not on the issue of the 9th Amendment or the 14th Amendment or anything like that. I think to go ahead and consider that abortion is banned is actually a violation of the 13th Amendment. I think that if a woman is forced to carry a child that she doesn't want to carry, that's slavery. And the 13th Amendment of the Constitution outlawed slavery. Now, that might seem to be a rather avant-garde way of thinking, but so is the kind of intellectual gymnastics that this court did in order to arrive at the conclusion that it did. So let's see where it goes. Any other questions? If there's one thing that I would like to have as a takeaway from this, inshallah, if you could do, is, first of all, every June, just like how you have Oscar week coming up in the next few weeks, and there's that anticipation, at the end of June is the end of the Supreme Court's term. The term ends on June the 30th, and it starts on the first Monday in October. Pay attention to the cases that are coming through and see how they might affect you, your families, and the Muslim community. Some of these cases might seem to have nothing to do with any of those groups that I mentioned, and in other ways they have everything to do. When Citizens United came down in 2010, most people thought, oh God, another boring case dealing with campaign finance and all, it's just about money, 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 money. But the case was about speech. And the case then became about how much you could give and the fact that donations were considered to be a form of speech. They also then decided that corporations in that way were citizens, and them giving donations was also a form of protected speech. And now we're at the point where we are, where the amount of money that goes into campaigns is, even for a simple congressional race, in the hundreds of millions, if not billions of dollars. So what are the implications of that, especially when we as a community don't have the kind of resources and funds to even fathom putting them into these kinds of issues or ways to protect the community. So please be vigilant about that, inshallah. Assalamu alaikum.